welcome to the Joint Committee on Fixed Term Parliaments Act. This morning we're taking evidence from Lord Hennessy and Professor Robert Hazell to continue our examination of the consequences of the Fixed Term Parliaments Act and also the government's proposals for its replacement. So can I first ask, please, Maria Miller to start off. Oh, sorry, Professor Hennessy, you did ask to make an opening statement. Would you like to do that?
That's very kind, Chair. Not having put in a paper to the committee, to clear my mind for this morning's session, I wrote down a list of the tasks that seem to me to have been placed upon you as Parliament's scrutineers of and advisors on this draft bill. I hope this isn't presumptuous. If it is, you'll forgive me, I hope. But I framed it in terms of what a PhD student of mine working on a thesis on the FTPA and its fate in, say, the 2040s might draw out as significant about this particular piece of constitution crafting. He or she would see it, I think, as embracing the need, first of all, to find a blend of predictability and flexibility in the new arrangements, with a bias towards dispute resolution at times that are likely to be characterised by a high degree of political inflammation. Secondly, to reinforce a high level of personal conduct on the part of the key players, the so-called good chaps theory. Thirdly, to find a high degree of consensus about the utility and desirability of the new measures to boost their durability, a point strongly made by the House of Lords Constitution Committee, of which I'm a member. Fourthly, to find a means of avoiding the placing of excessive personal power in the hands of an incumbent Prime Minister. Fifthly, to find a way of suffusing all proposed arrangements and procedures with what the Constitution Committee called the cardinal principle that the sovereign is neither politicised nor appears to be politicised by the operation of said arrangements. Sixthly, to maximise the chances of the new dispensation providing arrangements for all political seasons to permit the durability of the resulting settlement, thereby avoiding the risk of it being sculpted to fit a particular moment, need or contingency. Because what emerges, as Robert Hazell and Mack have said in their written evidence, will be one of the fundamental constitutional texts of the United Kingdom. And finally, to ensure that whatever settlement is reached should be as comprehensible as possible for the electorate in terms of its purposes and operations. And that, Chairman, I think is quite a stretching set of tests. And it buttresses my belief that you cannot merely repeal the FTPA and sink back with a soothing sigh onto the soft cushions of the conventions and assumptions that for so long have been our country's way of handling such matters.
Okay.
Lord Chairman, may I just add three sentences?
Okay, just one. Thank you. And obviously, Robert, if you want to add a few comments, please feel free. Robert.
It will be very brief. I've watched all the committee's previous evidence sessions, in particular the masterclass you had last week from Anne Toomey and Professor Philippe Lagacé, and it's pretty clear that the government's draft repeal bill is seriously defective. Almost all your witnesses have been agreed on that. So rather than add to their criticisms or simply repeat them, because I have little to add, I shall try in my responses today not to be critical, but to be constructive and suggest what might go in a more lasting piece of legislation to replace the Fixed Term Parliaments Act. That's all I wanted to say. Thank you.
Thank you, Robert. It was certainly been some very interesting exchanges over the course of the committee's deliberations, and I hope we can reflect that when we come to find the report. Maria, would you like to start us off, please? Maria Miller.
Thank you, Chair, and thank you, Lord Hennessy and Professor Hazell, for setting out the challenge that we face as a committee. And I think to start our conversation today with you, and thank you so much for agreeing to give evidence to the committee today, could you set out how you understand the conventions on dissolution and government formation to have operated prior to the passage of the Fixed Term Parliament Act? And could I start with Professor Hazell's response to that question?
Yes, the conventions on dissolution and government formation were helpfully summarised in the Cabinet Manual draft chapter, which was published in February 2010. And it's set out in my written evidence submitted with Professor Meg Russell at paragraph 15. And if I may, Lord Chairman, just read one paragraph from the draft Cabinet Manual, It's paragraph 58, which states, "At present, the Prime Minister may request that the Sovereign dissolve Parliament so that an early election takes place. The Sovereign is not bound to accept such a request, although in practice, it would only be in very limited circumstances that consideration is likely to be given to the exercise of the reserve power to refuse it. For example, when such a request is made very soon after a previous dissolution. In those circumstances, the Sovereign would normally wish to know, before granting a second dissolution, that those involved in the political process had ascertained that there was no alternative potential government that would be likely to command the confidence of the House of Commons." I think that's a very fair and accurate summary of the conventions before the Fixed Term Parliament Act. Peter Hennessy will recall that he and I were involved at the time with a small group of other experts in advising the Cabinet Office about what the conventions did then amount to. And I have nothing to add to that draft paragraph, the paragraph from the draft Cabinet Manual of February 2010.
Thank you, Professor Hazell. That's really clear. Lord Hennessy, would you like to add anything to that?
No, I think that's spot on. I was very struck by the way Robin Butler, in his evidence to you, caught the expectations of the old ways of doing things beautifully, but also by the regret in his voice when he said about the assumptions that of good behaviour, as it were, on part of all the players, which I was mentioning in my opening remarks, that there is evidence that governments these days are less inclined to observe conventions if those conventions don't suit them than they were in the past. Now, there was a kind of elegiac element, I think, in Robin's evidence to you, of a departed, perhaps it's a departing world, where the good chap's theory, as it's called, could prevail. But I was always struck, and Robert's being very modest here, he was very crucial at the Ditchley Foundation meeting ahead of the 2010 election in November 2009. He chaired the syndicate with the Queen's private secretary there and Alex Allen, who was representing the Cabinet Secretary, and others, that enabled us for the first time to move to what became those paragraphs in the Cabinet Manual, to conjure up these assumptions and conventions into a piece of paper that was comprehensible and could be understood by all, and indeed was brokered, as it were, I think that's the right verb, with Alan Beath's the committee, the Justice Select Committee that he was then chairing. I'm sure he'll remember this, just in time for the 2010 election, and indeed the hung result of 2010. But the old assumptions rested very much on the Lascelles letter to the Times in May 1950. When you think back of how much load was that letter had to bear, I mean, never has the Times published a letter of such constitutional significance, pseudonymous though it was. And in 1991, 40 years on from the Lascelles letter, I remember thinking what we needed was an updated version of this. And so with my producer, Simon Coates, for a Radio 4 analysis documentary, we looked at this. And Robert Armstrong, who had been crucial in these matters as both Cabinet Secretary and Prime Minister's principal private secretary, spoke for all of them, the Golden Triangle, as it's called, of the Palace, Cabinet Office and Number 10, about what the assumptions were. And it's a strange world, isn't it, where our country depends, it's marvellous in a way, on a small letter, a transcript from a Radio 4 documentary, and a paragraph or two put together for the new Cabinet Manual over 45 minutes of a sandwich lunch in the Cabinet Office. And it doesn't strike us as odd, because we live here, we've grown up with this system. But it's a very serious matter. I'm in no way treating it with levity, but it's almost an Ealing comedy touch to some of this, really. So I was always struck by the fragility of the previous arrangements, but it became much less fragile as a result of the Cabinet Manual, particularly once it had been brokered through the Justice Select Committee. I hope that makes sense.
Chair, if I may, just to follow up on that. You talk about the importance of the observance of conventions. What could be done to encourage better observance of conventions if this bill were to pass as it is?
Well, it would take a cunning piece of drafting of Baldrickian proportions to do it, I think, but it would be rather wonderful if somehow you could engineer as part of your work the incorporation in the main body of the bill of those assumptions that are in the Cabinet Manual and sort of in the dissolution principles, which isn't a very adequate document, I don't think, that's been appended to the draft bill. into the main body of the bill. Now, it's difficult to get conventions into legislation, isn't it? Particularly if they're about good behaviour. Statutes are all about bad behaviour, all about criminal behaviour. That's second nature to statutes. But good behaviour, expectations of it, is very difficult. And the incorporation of the Sewell Convention into the Scotland Act 2016 isn't encouraging about incorporating conventions. There's another difficulty with this one. It's not written down anywhere. It's a state of mind about good behaviour rather than a piece of paper. But you do everybody a great service, Chair, if you don't mind me saying this, as a committee, if you could somehow, if you wanted to, if you could incorporate those assumptions of good behaviour into the main body of the bill. But of course, in the end, it all comes down to people and the maps they carry in their mind about what is proper behaviour and what is consistent with past practice and expectation, which is a very tricky thing, very hard to pass it on.
Thank you.
Okay, Maria, thank you. Lord Grocott.
Yes, thank you, Patrick, and welcome to our guests, witnesses. We've heard an awful lot about Lascelles principles and cabinet manuals, but if I could distill this, you might think unfairly, to the most fundamental and basic question in all this, which is, can we envisage circumstances, and if so, precisely what are they, in which a monarch would say to a sitting Prime Minister, the Queen's principal minister, who would, in almost all circumstances, command a majority, would be the elected leader of the biggest party in the House of Commons. In what conceivable circumstances at present can you envisage a monarch faced with a request from the Prime Minister, not for some random piece of arbitrary power, but to say, can we please go to the people for them to sort it out, that Her Majesty would then legitimately say, no, you can't?
Do you want to go first, Robert?
Well, Lord Grocott, your question begs quite an important assumption when you said that the Prime Minister commands the confidence of the House of Commons.
I didn't say that. I said it would be leader of the biggest party in the House of Commons.
Then please forgive me for mishearing you, because of course we all know that the Constitutional Convention, that the monarch must follow the advice of the Prime Minister, is dependent on that Prime Minister commanding confidence. And when the Prime Minister cannot command confidence, or when it's uncertain whether the Prime Minister can command confidence, then the Prime Minister's advice is no longer binding on the monarch. But in talking about dissolution, we're not talking about advice anyway. We're talking about the Prime Minister requesting dissolution. And that was gone into very well in your evidence session last week with Antumi and Philippe Lagacé. And there are circumstances in which the monarch would be justified in refusing a dissolution, and they are set out very clearly in the paragraph from the draft cabinet manual, which I read out in my answer to Maria Miller. But in brief, the circumstances are two. If the request was the request for dissolution was premature because it was too soon after the previous election, or secondly, if in the existing parliament an alternative government could be formed which could command confidence. And Professor Toomey explained that at some length in your session last week. And in effect, it was what she described as a baton change, a change of Prime Minister, perhaps within the same governing party. But Professor Toomey also added another circumstance when she said, if it was also potentially damaging for an election to be held, perhaps there was a pandemic, a war, or an economic crisis, there might then be a good reason not to hold an election in those circumstances, and the monarch could refuse a dissolution, appoint a new government, and let them get on with governing.
Bruce, can I answer your question with a dip into history when it was considered in relatively recent times, which is after the inconclusive February 74 election? And there was a question then, what would happen if Ted Heath faced the Commons, as he it was well in his rights to do so, and lost the Queen's speech? If he asked for another dissolution, the feeling was he wouldn't get it because he'd already had his election, that the Queen would therefore send for Mr. Wilson and give him a chance to form an administration. And if he tried and failed to get a Queen's speech through, he would get a dissolution. And the golden triangle of the day, Martin Charteris was the Queen's private secretary, and he rang up Sir John Wheeler-Bennet in Oxford to see if this was consonant with history. And this is the way these things were done in those days. And Wheeler-Bennet quoted Arthur Balfour in his memoirs of 1930 saying, "No constitution can stand a diet of dissolutions." And therefore it was checked with historical, as it were, the grain of history. There's almost poetry in this, really. And so that would have been the position if Ted Heath had met Parliament and had gone down on a Queen's speech and asked for another dissolution. And what in effect happened, I'm not sure, I could never sort this out by talking to people, is there was a view conveyed, I think, to Harold Wilson indirectly, that it would be better perhaps if he could hold on as long as he could. This is after he'd accepted the Queen's commission to form a minority government, as long as he could, before requesting another election, which is exactly what he did, as you remember, because it was held on till October 74. So it's a question of private chats, checking with the grain of history. There's a kind of beautiful choreography to all of this in the old days, which I'm sure Robin Butler was alluding to in his eloquent evidence to the other day. So that was the historical moment when this was considered by the golden triangle of the day as the way perhaps that was best to proceed. So those circumstances are an example of a very rare circumstance in which a monarch would refuse a request for another dissolution.
Well, it's always very helpful, Peter, when there are specific references to specific circumstances rather than a broader, almost academic discussion about what conceivably might happen, however unlikely that might be. But I certainly remember the February 74 election very well. It's one of many that I lost. But I still think that the fact that it took the two of you, very eminent witnesses, quite some considerable time to answer what on the face of it is, well, not a simple question, but a pretty straightforward question about when Her Majesty will say no to a Prime Minister, suggests that should we try and put this into legislation, that seems to me would be extraordinarily difficult. And I'd just like your comments on that.
Shall I go first briefly? I'm sorry it took us a considerable time. I was making just 2 points. That a dissolution could properly be refused. First, if it was premature, because it followed too soon after the previous election. Or second, if in the existing parliament an alternative government can be formed, which does command confidence. And those are the two limbs in the paragraph of the draft cabinet manual, which I read out at the beginning. I don't think, in answer to your question, Lord Grocott, those should be put into statute. I think it's perfectly satisfactory if they're left as a statement of the convention in the cabinet manual.
I think, Bruce, the language of the replacement legislation could help, though. The dissolution principles document, which I'm sure we're going to come to at some point, it has to make plain in the main body of the bill that the Prime Minister requests, does not advise, requests a dissolution, and that the advice given as the principal advisor to the Queen is not, as the palace used to distinguish it, capital A advice that has to be taken. In this instance, it's lowercase advice, which the Queen does not have to take, and the Queen can talk to whoever she wants about all this and take soundings, or not directly, her private secretary would do it. But that's the point that I think needs to be made. It needs to be the language of the Lascelles principles, if you like, needs to be conveyed into the statute if you can. I take Chris Bryant's point about the Lascelles principles when one of your previous sessions, when he said it's quite rare for them to feature in discussions in pubs and clubs. I recognise that. But the Lascelles principles, or at least two of the three, if as far as you possibly can, incorporating them into the legislation, or the expectations in the legislation, as well as having them in the cabinet manual, will be a great service, I think. There's some sloppy drafting in that page of dissolution principles. Although, I don't know if Chair you'll allow me, I was very struck by Chris Bryant's observation about the lack of public heat about this particular question, although on the morning after an inconclusive result, the Cabinet Manual suddenly takes on great importance. I remember in 2010, Robert and I and Peter Riddle and others were farmed out to be on various bits of the media to be kind of an incarnation of the constitutional assumptions, a slightly embarrassing position to be in. And the Cabinet Manual became a topic in the pubs and clubs. Indeed, for a few hours, they spoke of little else. So there are moments when this goes from being something, you and I have both taught this as university teachers, Bruce. It's the hardest lecture of all, is to get the students aroused by a constitutional historical lecture, isn't it? But suddenly it can flare into sort of prominence, preeminence and great salience almost out of the blue sky, as it did in the 2010 election, as you remember. Another very long answer, I'm sorry, but there we are.
Thank you both very much.
Chairman, may I
Peter,
add something?
can I just, Robert, I can come back to you in a second. Peter, can I just ask, whether you think that the golden triangle that you described in February 74 would be as effective today as it was in February 74?
I don't think it would be, Chairman, because it's what Robin Butler was saying in that very measured way of his the other day, is that I don't want to be unkind to anybody, really, because it's a tough job being Prime Minister, or as it is being monarch. I mean, anybody involved in all of this, particularly at these difficult times. But there's almost a tin air these days in certain circles in Whitehall about the sensitivities of all this compared to the old days. And also there is a natural suspicion in the country we now are of shadowy figures of whom very few people have heard, getting on the phone to somebody in Oxford to check what the Constitution is and producing a kind of decorous fix while walking round St James's Park on a Saturday morning after an inconclusive election. It's not quite the way we do things these days. We've gone from being a back of the envelope nation to a code, the front of a code or the face of a bill nation, I think. So those days are quite difficult to reconstruct. Though this is in no way to diminish the continuing importance of the Golden Triangle. But I think it's Philip Ziegler who actually invented that name for them, the Golden Triangle, not me. But Philip also had the rather good concept that they operated on the basis of instantly invented precedents. And that was the way it was done. I remember talking to one of the triangles in the run-up to one of the elections that might have been inconclusive in the 90s, I think, probably 92. And I said, are you getting ready for this? And he said, well, yes and no, because there's an awful lot you can do between an election being called and it happening. You can always go to the cupboards, which struck me as, again, a wonderfully indicative way of the way the Brits do it. You go to the cupboards and get the files about what happened last time and tweak them a bit to suit current circumstances. But I think it's quite hard to persuade people that's an entirely desirable way of proceeding these days. Though, like Robin Butler, I have a certain nostalgia for it, really, myself, because in its strange and mercurial way, it did the business, although there was always a high level of anxiety that accompanied it, always. As Martin Partridge said about 1974, it was a very dicey weekend. There's a lot of diciness involved in all of that.
Sorry, Robert, I cut across you. Did you want to just come back on that point?
Yes, forgive me, it's a very brief point. But it's only because the government wishes to revive the prerogative power of dissolution that we're having this discussion about the conventions, the old conventions, and what they mean, and whether modern day politicians could be relied upon to observe them. And it's possible to devise a replacement bill which is less reliant on conventions, or indeed not reliant on them at all. But I hope we'll come on to that in discussion further on.
Okay, can we move on then to Alan Mack, please?
Thank you, Lord Chairman, and thank you, Lord Hennessy and Professor Hazell, for joining us this morning. I want to talk about motions of confidence and matters of confidence, which are both important parts of the dissolution architecture. Prior to the passage of the Fixed Term Parliaments Act, what in your view constituted a motion of confidence or a matter of confidence? And perhaps we can start with Lord Hennessy.
Again, I think they were the ones that was a pretty strong agreement. There would be a Queen's speech, a budget, a policy that the government was central to the government's programme, or a straightforward motion of confidence brought by the leader of the opposition. Those, I think, were the four classic occasions when it was expected that these things could arise. And the Fixed Term Parliaments Act, of course, which is part of what you're wrestling with, brought it down to specific wording and specific contingencies. And it made it, in some ways, much less clear. For example, I'm sure we'll come on to this, but the bit that certainly worried the palace more than anything else about the Fixed Term Parliament Act was the 14 days in which you might or might not find an alternative administration. They worried about it as a kind of howling void in that legislation, because it was much it was a specific replacement for those assumptions, but it actually made the position much worse, I think. It was quite easy for all of us to understand what confidence was in the old days, but the Fixed Term Parliaments Act made it particularly difficult, particularly the 14 days provision, which was deeply unsatisfactory. I don't know if Robert would agree with that.
Robert?
I have nothing to add to the list of matters which Peter Hennessy has given you, which would count as issues of confidence. And they are the same as the list which was given to you last week by Anne Toomey and Philippe Legasse. But I would add that, in my view, none of this has changed as a result of the Fixed Term Parliaments Act, save that a formal vote of no confidence is now given statutory form with statutory consequences. And in saying that none of this has changed as a result of the Fixed Term Parliaments Act, I would refer you to the very impressive reports from the Commons Public Administration and Constitutional Affairs Committee of December 2018 and from last year, September 2020. And if I could just read two paragraphs from that second report, the one of September of last year, PACAC said this: "The issue of confidence is central to the UK's system of parliamentary democracy. The Fixed Term Parliaments Act has not changed this fact, as our predecessor committee clearly set out in its report, The Status and Effect of Confidence Motions and the Fixed Term Parliaments Act 2011. In this report, PACAC clearly established that the FTPA included a route under Section 2.3 by which a no confidence vote could directly trigger a general election, but this did not replace the pre-existing conventions regarding confidence. This previous conclusion was endorsed by Professor Toomey in her evidence to this inquiry, stating, 'It is clear the conventions regarding confidence were not dispensed with as a consequence of the application of the Fixed Term Parliaments Act.' And the PACAC report went on to refer to similar evidence from Sir Stephen Laws, saying, Sir Stephen Laws, who oversaw the drafting of the Act, went on to explain that the Act did nothing to change the precedents surrounding confidence." And Chair, I'm quoting from paragraph 70 and 71 and 72 of the PACAC report of September of last year.
Okay, thank you. Alan, do you want to come back on that at all?
No, that's all for me. Thank you both.
Okay, thank you very much. Aaron Bell, do you want to come in with your question, please?
Yes, thank you, Patrick. Just following on actually from the answer you just gave Alan first, and Lord Hennessy, you said something central to the government's agenda would be considered a matter of confidence. Clearly, I think you could make a very strong case that Theresa May's Brexit deal came under that category, even if you don't think David Cameron's military intervention in Syria did. And clearly the Fixed Term Parliament Act, therefore, what happened with those seems to have changed those conventions. Would you agree with that, based on your reading of what happened with those votes?
Well, the part of the big debate is whether that circumstance that you all lived through, particularly in the Commons, in last year, 2019 rather, was freakish. And I've always thought that that was as much the product of the political culture that you were all living and working in as anything else, really, because the European question has always vexed this country. It's driven people, otherwise rational people, mad at regular intervals, and it cannot be contained by the left-right structure of our parties. It's divided them from within, which meant that when it comes up as an issue in the Commons, it can go in also, it's a kaleidoscopic issue, as well as a great anxiety and heat-inducing issue. And also you had, again, I'm trying to find careful words here, a speaker who took an activist view of his office, almost an imperial speakership, really, and changing the understanding of the standing orders. When you put all that in the mix, I think it was a sort of one-off freakish occurrence rather than something that we could expect to be repeated again. Of course, nothing's repeated again in quite the same way. There's no kind of iron laws of history on that. So I wouldn't put too much weight myself on that, although I remember coming in as a young lobby correspondent in '76 to the House of Commons. And in my first week there, the Wilson government lost a vote on its public expenditure white paper, which was indeed central, because we were in the middle of a huge economic crisis. And they got the confidence vote, which they won the next night. It goes down in political history, that one, because Dennis Healey, the Chancellor, came in late and shouted at Eric Heffer, who accused him of being a Stalinist. It was the most wonderful political theatre. I mean, how innocent seem those days compared to the crises we're now living through. I mean, what's the Sterling crisis these days? That's just a sort of side thought. But that was the standard way it was done in those days. If you lost something of central importance to the government, you had a confidence vote very quickly thereafter, and you usually restored the position. So again, all that was part of the understandings. But I think the European question and the travails of the Johnson government, which led them to set aside, with the notwithstanding legislation, the Fixed Term Parliaments Act, was sui generis.
So you wouldn't draw a convention, the convention itself has changed off the back of that then?
No, I really wouldn't actually.
I should say that I happily was not living through that. I wasn't an MP at the time, but I think most of my colleagues on this committee were. Professor Hazell, did you want to add anything to your understanding of whether those votes altered the conventions around no confidence?
Well, briefly, if I may, I think the conventions and their understanding have changed, but for other reasons. And if I could just remind you of the evidence that you received last week, Professor Toomey, having enumerated defeat on the Queen's speech, losing the budget, etc., as examples which clearly are issues of confidence, said at the end, she acknowledged it was an old list dating from around the middle of the 20th century. And Professor Lagasse then added, I would say that notion that the government must get its way on major policy and must be able to control what occurs in the Houses of Parliament is fraying in the United Kingdom. I suspect in an era of far greater backbench independence in the UK, that might not be as well seen as it would have been in the past, as Professor Toomey indicated. Speaking for myself, I agree with that. In an era of what may be more frequent minority or coalition governments, our understanding of what constitutes loss of confidence may gradually change, because governments will be more frequently defeated in Parliament, including on major matters, without that necessarily counting as loss of confidence. But of course, it's still open to any government to formally declare an issue to be one of confidence.
Thank you. And if prior to the Fixed Term Parliament Act, the government was defeated on something that was explicitly a matter of confidence, either because they called a vote and made clear that was the case, or it was the Queen's speech or a motion of no confidence, what course of action ought then to have followed? Would it almost automatically be a dissolution now, or is the option of resignation still there for a government?
The option of resignation is absolutely still there. There are two alternatives. The government either requests a dissolution or tenders its resignation.
Thank you. And Lord Hennessy, any further points about that?
No, I agree with Robert. Yeah.
And what's expected? Does that depend on the circumstances, the political circumstances and the length of time since the last election?
Yes, it depends very much on the political circumstances. So in thinking about this, I mused another hypothetical situation when I wondered, suppose that Harold Wilson had lost the first, as it were, Brexit referendum, or rather the Brentry referendum, the 1975 referendum on the renegotiated terms of accession to the European Community. And suppose that he then proposed to his Labour cabinet colleagues that he should seek a dissolution. But suppose that the colleagues were opposed and they said there's an alternative leader who could lead the party and command the confidence of the House of Commons. Now, in those circumstances, I would have expected Harold Wilson to have offered his resignation and to advise the Queen to appoint the leader of the alternative faction in his place.
No, I don't think so.
Now, we can all dream up lots of similar kinds of scenarios, but resignation is definitely an alternative to a request for a dissolution, depending on the political circumstances.
Thank you. Thank you, Chair. That's all from me.
Thank you, Anne. Baroness Lawrence, please. Doreen? You're muted. I think you need to unmute, Doreen. Thank you.
Yeah, I've done that. Sorry about that. Thank you, Chair. When Lord Hennessy was talking to the first question, he sort of referred to about good behaviour. which leads on to my question. Prior to the fixed-term parliament, the prorogation power of dissolution was regarded as personal or constitutional prorogation, rather than one that was exercised by a minister. What do you understand this to have meant? Lord Hennessy?
Well, it was the Queen only had two personal prerogatives left, or three really, I suppose, before this act. One was appointing a prime minister, and one was dissolution, and the other one was prorogation. And the royal prerogatives are a very interesting thing, because I remember that extraordinary man Enoch Powell once saying that the greatest gift of the British monarchy is to give its absolute powers absolutely to Parliament. But I never thought that quite fitted, because quite a lot of the prerogative got stuck halfway in Whitehall. But it all shifted from the Queen, apart from those personal prerogatives, and they stood alone, Doreen, as something very significant and very different. And they fitted with the much wider concept of the Queen as a constitutional backstop against improper behaviour by a Prime Minister. And we've seen, I think, perhaps I shouldn't bring in the United States experience because it's not directly relevant, but it's a great idea, I think, to keep the head of state separate and a different person from the head of government. And so there's a notion which fed into those personal prerogatives, which is why their utility has lasted for so long, or did do until the Fixed-Term Parliaments Act, is that you had the Queen as a constitutional backstop, and who would, of course, be drawn into political circumstances, but not party political circumstances. That was a kind of genius of the old arrangement of the personal prerogatives, but all of this is intensely political. And the question of confidence, as the Pack Act report put it so well that Robert was quoting, about confidence being central to the whole notion, our notion of parliamentary government. But at the same time, the Queen was in a position of being detached from the party political elements of it. And it was always, the understanding was, the politicians would have to sort it out amongst themselves and bring a solution to her, to give her good housekeeping seal of approval, as it were. So that, in a roundabout way, is how I would regarded those personal prerogatives, the remaining personal prerogatives. But then, of course, the question arises, which is one of your great dilemmas, is can you revive the personal prerogatives if they've been removed by statute? Can they rise Lazarus-like, you see, from constitutional history? I hope that's not entirely clear, Doreen, but the whole business isn't entirely clear. It's this peculiar bundle of custom and practice, conventions, statutes, expectations, out of which you have to make something sensible and palatable, which is a tough task.
Robert?
I presume that's what probably happened back in 2019, when we had that difficult situation where the Prime Minister had gone to the monarch to dissolve Parliament. So I presume that's part of all of that. Professor Hazell, have you got anything to add to that?
Yes, and just this, you asked prior to the Fixed-Term Parliaments Act, what does it mean that the prerogative power of dissolution was regarded as a personal or constitutional prerogative? And my answer would be that it means that it was discretionary, namely that an improper or untimely request could be refused. And there are examples of it being refused in other parts of the Commonwealth by the Queen's representative, the Governor-General. And the notable examples, which again, Anne Toomey and Philippe Legacy referred to last week, where Gough Whitlam being refused dissolution in Australia in 1975, and in Canada in the King Byng affair, when Mackenzie King was refused dissolution by the then Governor-General Lord Byng in 1926. And on both occasions, it did lead to, it was the peak of a major constitutional crisis, but dissolution can be refused, and occasionally it has been refused.
Okay,
thank you.
Okay, Doreen, thank you. Robert Goodwill. Robert, I can see you. You're obviously froze and not able to hear what we're saying.
He says his internet's gone down, Chair.
Oh, right. Okay. Can I come back to Robert, hopefully on 2011 later on. Can we move on to the Constitutional Convention then? Lord Jay.
Thank you, Chairman. There's a constitutional convention that the monarch has kept out of matters of party political controversy as far as possible. And obviously some of the things we've been talking about dissolution, government formation and so on, do risk or would risk bringing her into politics. And you've talked, or Peter Hennessy has talked already about some of the safeguards which existed under the old system in the event of a prime minister going slightly adrift. The Golden Triangle operating in a mixture of Oxford and St James's Park, for example. I wondered if you wanted to add anything to that, and whether you had any thoughts on whether, in the light of the 2019 prorogation dispute, do you think we need new arrangements to ensure the monarch isn't drawn into party politics, and what form might those take? And might there be a role for Parliament here, or the courts here, or wise people in some form or another, formal or informal? Perhaps you could comment on those questions.
Robert, do you want to go first?
If you like, and if I may, I'm going to offer an answer about bad faith in a slightly different sense, because this is a really important aspect. And that is that under the old system, there were no safeguards against a prime minister calling an election at the time most favourable to them and their party. And I know that some on the committee have questioned whether this really conferred an advantage, citing examples like Theresa May's early election in 2017. But the evidence from Professor Petra Schleiter's research is incontrovertible. Doing a systematic analysis of all elections since 1945, she concludes that allowing the Prime Minister to choose the election date confers an advantage of around 6% in votes and 12% in seats. If I can quote the conclusion from her article in Parliamentary Affairs in 2016, incumbents have on average realised vote share bonuses of just under 6% and seat share bonuses of 12% in elections scheduled for partisan advantage. And she goes on, moreover, prime ministers had a 40 to 50% better chance of surviving in office in such elections. Now, the reason I want to mention this is that's not trivial. That's a seriously unfair advantage. I know that the government denies that, and if any of you on the committee still deny it, I feel you really ought to invite Professor Schleiter to give evidence, because her research is greatly respected in the academic community. She has submitted evidence to this committee and previously to PACAC. You cannot ignore her evidence or sweep it under the carpet. So you must accept that if we revert to the old system, where the Prime Minister chooses the election date, that introduces a significant element of unfairness into our system of elections.
Michael, I was horrified by the prorogation story of August 2019. I really did feel the Queen should not have been put in that position. I was perhaps in a somewhat inflamed state when I was asked by Radio 4 to comment, and I said, I could feel the good chap's theory lying in shards between Her Majesty the Queen and those Privy Councillors at Balmoral on that day in August 2019. And that was what I meant about tone deafness on the part of some people to the niceties. She simply should not have been put in that position. And indeed, I think the Constitution Committee of the House of Lords, when it looked at the Fixed Term Parliaments Act, initially thought it was inconceivable that there'd ever really be a problem with the prorogation. But we were quite wrong about that. So I think I'm still recoiling from that. I can't quite believe that that happened. And it was deeply, deeply unfortunate. And I think I'm very keen, I know that we'll come to this in a minute, that the way to resolve pretty well all these things is to have a proper clean vote of the House of Commons on it, where a simple majority will suffice. This is what I meant in my opening thought about making sure that the powers of an incumbent Prime Minister are not excessive. If the good chap's notion doesn't hold anymore, you have to write things down. That's one of the sadnesses, really. But I think the prorogation story of August 2019 and the subsequent Miller-Cherry case were a real shock to the system. All sorts of assumptions about personal behaviour went up in smoke, didn't they? I don't know if you agree with. It's not for me to ask questions, Michael, but I have a slight suspicion you would agree with that. Though you would use more careful language than I have because you're trained to.
You talked earlier on, Peter, about the need for the right balance between predictability and flexibility. Are you talking here really about moving further down, quite a long way down that spectrum from flexibility to predictability to prevent this sort of problem happening in the future, particularly if people are going to behave in rather different ways than they have done in the past?
Exactly. I think the flexibility comes in trying to create a system with the replacement legislation that is good for all seasons and good for all circumstances, but at the same time has a predictability because it's the Commons that matters. The Commons expressing its view on these things is what matters, and that makes it understandable to the electorate, I think, because they understand votes. Not fancy franchises, to use the 19th century phrase, but straightforward, clean, simple majority votes in the House of Commons. Everybody understands what that means. So I think that's the solution probably I would recommend that we get to. And that's where dispute resolution must take place in our system. It has to be on the floor of the House of Commons.
And can I ask just Robert Hazell? I mean, from what you were saying, you were also suggesting that we need to move quite some way down the spectrum from flexibility to predictability. Is that right?
Indeed, and please forgive me, Lord Jay, for not giving a more direct answer to your question previously. But on this question in particular of prorogation, I myself said in evidence to the Lords Constitution Committee, as it happens, I have the date of my written evidence, which was the 15th of August. So it was submitted 2 weeks before the prorogation actually happened at the end of August 2019. And I said this, that prorogation, its exercise has normally been uncontroversial to end a parliamentary session. But given the risk of possible abuse, it would seem wise to ensure that Parliament cannot be prorogued against its will. One way to do this would be to make the prerogative power exercisable at the request of Parliament, rather than on the advice of the Prime Minister. And I think, in effect, Peter and I are saying exactly the same thing on that particular point.
Yeah.
Thank you. Thank you very much, Chairman.
Okay. Michael, Robert, I think we've got Robert Goodwill back now. So, Robert, do you want to come in on your... Then I'll come to Chris Bryant after that.
Yes, thanks very much, Patrick. My question was about, in effect, whether the Fixed Term Parliament Act painted the monarch into a corner. So, and probably could I start with Professor Hazell? So by early 2011, was there any meaningful sense in which the prerogative powers could be exercised contrary to the advice, with or without a capital A, or a request or recommendations from the Prime Minister of the day? And could the monarch still be said to be a real safeguard against the abuse of prerogative powers by the Prime Minister or the government? And indeed, we had a situation when Parliament was prorogued, and obviously the Miller cases questioned that. So I wondered if actually the powers were still there in any sort of vestigial sense, or completely removed by the Act.
Well, I think the monarch was still the ultimate safeguard, and still is. The draft cabinet manual was quite clear about that. It said the sovereign is not bound to accept such a request, meaning a request for dissolution. But coming on to your point about prorogation, it might be thought that the Queen's acceptance of the Prime Minister's advice on prorogation in August 2019 has rather undermined that. Yeah. But I would suggest the reverse. I think what will happen if in the future any Prime Minister seeks to shut down Parliament through a prorogation which is untimely or unduly long, the monarch will not want for a second time to have an order of prorogation to be declared unlawful, null, void, and of no effect. So I would expect the palace to quiz the Prime Minister hard over any future request for prorogation to ensure that prorogation is lawful and justified within the guidelines laid down by the Supreme Court. So instead of, or in addition to the Lascelles principles on dissolution, we now have the Hale guidelines on prorogation. But as Peter and I have both suggested, there are other ways of avoiding abuse of the prerogative power of prorogation, namely by making prorogation exercisable at the request of Parliament, rather than on the advice of the Prime Minister.
And the ouster clause, presumably, is to prevent that happening again.
Yes, we may come on to the ouster clause, but in my view, it's highly undesirable because it leaves the monarch, in effect, without the protection of the advice about constitutional principles, which the Supreme Court handed down last year in 2019, in the prorogation case.
Thank you. Lord Hennessy, have you any observations to add?
I agree with Robert. I just had one thought, that it was significant, I think, in Robin Butler's evidence to you, that he still regards the monarch as the last resort against truly improper behaviour by a prime minister. There's still the power to dismiss. I mean, it's almost inconceivable that would happen. And also Robert Armstrong was the same in 1991 in the documentary transcript when we asked him to update the Lascelles criteria. These are almost inconceivable circumstances, but this sounds a little bit alarmist, but if you'll allow me, Chairman, there was a moment when there was a great flood of Cold War documents declassified after the Cold War was over, nuclear release procedures and whatnot, and how the Prime Minister is the only one who can authorise a nuclear release. And I remember the great Sir Frank Cooper, who was a very tough operator, permanent secretary of the Ministry of Defence, sitting me down, rather aggressive man, Frank, and he said, "You've never understood the British Constitution, you know." I said, "In what way?" He said, "Well, you asked me the question, what would happen if a Prime Minister went mad and authorised nuclear release when there was no military justification?" He said, "Well, the Chief of the Defence Staff," he said, "the Prime Minister is not the Commander-in-Chief of the British Armed Forces, the Queen is. So the Prime Minister can't give a military order. He can authorise, but he can't give a military order. So the Chief of the Defence Staff by his side would say there's no military justification for this. So the Prime Minister of the day, if so moved, would have to sack the CDS. And," said Frank, "only the Queen can appoint a new CDS, which takes a while, but gives you plenty of time for the white coats to come in and sort the Prime Minister out." Now, again, I don't want to cheer you up, and we've got enough to worry about in our poor old country at the moment, thinking about a mad Prime Minister and nuclear release. But Frank Cooper actually talked about the informal constitution there, and the Queen's role in that case would be not appointing a CDS pliable enough to do what the Prime Minister wanted. I mean, that's a very grave contingency. But I think you asked Robin Butler about what would happen if a Prime Minister sent a mob down to sack the House of Commons. And that was quite an interesting answer as well.
Maybe you have to be a little bit mad to even want to be Prime Minister, but I wonder if the situation would have been any different that autumn if we'd had a speaker who was more of a referee and less of somebody who was wanting to play for one of the sides on the pitch.
Well, I think, I don't want to be unkind to Speaker Bercow, but I think history will record one thing about him, that nobody was neutral about him. Some people thought he was a great tribune of the people and of backbenchers and so on, and others took a different view of his style and level of activity, if I can put it that way. But I'm not sure I want to get drawn into that one.
Thank you. I think that's probably...
Leave that to another PhD student of mine in the future.
That's probably enough said. Back to you, Chair.
Well, Lord Hennessy, I think you complimented Lord Jay on his diplomatic answers. I think you must have been either learning a heck of a lot from him over the period of time in the answers that you've given on that particular subject so far this morning. Could I just possibly put one point to you, though, Lord Hennessy? And that is when we're talking about the prorogation in 2019. Of course, it did seem a long time, but normally the House of Commons would have risen for the party conferences. And actually, by the time you'd taken out the party conference recesses, actually that prorogation was not as extended as it seemed, the way in which Parliament would normally have happened. And there was a Queen's speech that had already been announced.
I take that point, but it still struck pretty well everybody as unnecessarily long. And of course, intentions were suspect, weren't they? That was the difficulty.
Okay, thank you. Chris Bryant.
I won't get into that one, Lord Chairman. Can I just ask one preliminary question, though, which is about Lord Hennessy. You referred several times to two phrases, good for all seasons, which I presume means that we need to have some kind of set of constitutional arrangements which work whether you have a good guy or a bad guy or a bad woman or a good woman, both as Prime Minister and actually as monarch as well.
Precisely, yes.
if you just rely on a simple majority in the House of Commons, when a government can change the standing orders, can change legislation, etc., 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 isn't there a danger that it's very difficult to achieve a constitutional set of arrangements which are good for all seasons?
I would agree with that, but you could increase the chances as much as you possibly can. In the end, there's no guarantee against bad behaviour, really, is there? But I've always thought that our constitution, with all this peculiar mixture of custom and practice and conventions and statutes and so on and codes, somehow could take the strain. Perhaps it's a British conceit that I share with, I suspect, quite a lot in the country, that we have a genius for muddling through. That it may not be right. Jim Callaghan spoke for pretty well everybody in that radio documentary in '91 when he said, well, it works, doesn't it? It may be on the back of an envelope. You didn't have to write everything down in a written constitution. I mean, Jim was a very shrewd judge of these things. But I have a version of that in my own head, that I do think that the combination of restraints that we have, by and large, do encourage good behaviour most of the time. But you cannot legislate against rogues, can you? Capital R rogues as well as other sorts of rogues.
I'm afraid this may be a personal point, but it doesn't feel as if we have a system that limits the power of a prime minister. And if you simply rely on a majority in the Commons, where they can suspend standing orders every day of the week, and they can refuse to abide by a convention, for instance, that says that a piece of secondary legislation that has been prayed against by the leader of the opposition shall be guaranteed a time on the floor of the House and a vote. That's been suspended best part of 40 times in the last year.
Yes.
I would say that where nostalgia isn't going to serve us very well.
Nostalgia has its uses because we all have a certain idea of what proper behaviour is, Chris, I think. We're still, the great virtue of this country, it was at the time of the expenses scandal, I thought this too, is that we're still shockable by bad behaviour. And that in the end, governments will pay a price for it.
And get re-elected.
Well, no, I was thinking the gods of politics are wrathful bastards, Chris. You know that. They'll get their comeuppance one day.
Just tiny questions. Amendment about votes no confidence. People have said losing a vote on the Queen's speech. Does that include losing an amendment on the Queen's speech, or just losing the Queen's speech?
Well, Robert, I don't know what you think, but I would have thought losing the Queen's speech as a whole. Maybe I'm wrong about that.
Historically, it's been an amendment.
Yes,
yes, previously it has been an amendment, Chris. You're quite right. Yes, that is the standard assumption. Yes, of course, my brain is a bit cloudy. You're quite right. That is right. Yes, an amendment of the Queen's speech would qualify. Forgive me.
And the convention, Professor Hazell.
I agree with that. And if I could just add on your earlier questions, they go to what Peter Hennessy was saying right at the beginning about any replacement for the Fixed Term Parliaments Act needing to be robust and to stand the test of time. And I hope we might come on to discuss what ideally should replace the Fixed Term Parliaments Act, but I think it's possible to devise a replacement set of rules which is not so reliant on conventions, that it can only work with good chaps in government. It must be robust, as Peter said, for good times and for bad.
And which takes me on to a different question, which is about the effect on the electoral cycle. Is it a good thing or a bad thing to have a generally predictable time when general elections shall be held?
Shall I go first on that?
Yep.
It's clearly a good thing. And I thought that Anne Toomey was very eloquent when giving her evidence to you last week, not least because she wasn't talking about it from a purely theoretical point of view. She was talking about her experience as a former public servant in New South Wales. And she told you very clearly the advantages that predictable election cycles have in terms of effective planning in government. And if I can refer briefly to my own experience, I was myself a civil servant in Whitehall for almost 15 years in the old days, pre the Fixed Term Parliaments Act. And I can still remember from about the third year onwards of a parliament, the debilitating effect of the speculation in the media and around the traps in Westminster and Whitehall of will the Prime Minister call an early election? And it did hamper our planning of the legislative programme in the final years of the Parliament. It did hamper our funding programmes and the like. It was very debilitating not knowing clearly when the next election would be held, and it's a very clear advantage of fixed terms.
Professor Hennessy.
Chris, I'd agree with that. Though I was worried when the 2011 Act, the bill was going through, that I would have settled for 4 years, because that seemed to be the biorhythm we got used to.
Yeah.
And it seemed more natural to go with the natural biorhythm as established by custom and practice and recent history than to go for 5 years, because you get the fifth year blight, I think people called it. So I was worried about that. But overall, I think the expectations of general elections, a 4 year term would be my choice. And I think the 2011 Act did change expectations. And indeed, we had an election on schedule in 2015. It seemed to be doing its stuff, didn't it? But I remember Robert Armstrong saying in the debates in the Lords on the 2011 bill that an incoming government, it might be preferable for an incoming government to have a resolution passed in the House of Commons noting its expectation that this Parliament would last for 5 years. You didn't need this full-blooded statute to do that. And it would be better left to each incoming government to decide whether it wanted to be like this or not. And I think he put that as an amendment, which was lost. And I thought that was one way of doing it too.
I think I tabled the amendment which said 4 years instead of 5, but
we think as well.
A simple majority in the House of Commons defeated it. It's not exactly 5 years either, is it now? It's 5 years plus a bit.
Yes, yeah. Yes.
Which would make it the longest in the world?
Oh, I shouldn't think so, is it?
Of a parliament?
Of a proper parliament, anyway. It might be of a proper parliament, yes.
I've finished, Chair.
Okay. Peter, you just talked about a 5 year blight with a fixed term parliament of 5 years. If you had a 4 year parliament, wouldn't you have a 4 year blight?
I think, Patrick, governments are much more knackered in the 5th year than they are in the 4th. It's a physical thing as much as anything else. There's only so much people can take these days, isn't there?
Okay, thank you.
I remember Douglas Hurd, the wonderful Douglas, saying, he was talking about John Major's government, I think, and he said, of course, you get to a point where whatever you do, they don't want you. And it affects people terribly, but terribly badly. And there's that human side of it as well, you see.
Yes, but that was. I mean, presumably Douglas was talking about the 92 to 97 Parliament, where the government had been in office for a very long time and was harbouring under a very small. Well, by the time we got to the 97 election, a minority government. I think it possibly depends on the cycle, but we can take that further forward. I better move on and not dominate too much. Can I move to Angela Eagle, please, for her question? Angela?
Thank you very much, Patrick. And I remember the 92-97 Parliament with some nostalgia, as it happens. Lord Hennessy, you observed at the beginning of your evidence that the bill to replace the Fixed Term Parliament Act will become one of the fundamental constitutional texts of the UK.
That's Robert's phrase, actually, which I lifted from his evidence.
Fine.
Yes. Sorry to interrupt.
Well done for attributing it to Robert. I'll come to Robert in a minute, but is the bill as currently drafted up to it, and how would you change it so that it could hold the weight that is expected of it as a fundamental centrepiece?
Well, it's an extraordinary bill. It's a shout of rage in a way, Bill. And also, I've never seen a statute before which Section 2. We're required by this legislation to treat it as all a bad dream that never happened. It's an extraordinary injunction, Section 2, isn't it? Sort of
Back to the future.
Yes, that's Back to the Future. You know, a bit of amnesia is required on all our parts. It's a very, very peculiar statute, this one. And I think it's been drafted in a fit of pique, which is never a good basis for legislation. Also reacting to those very peculiar circumstances in 2019. That's the weather system it's reflecting, which is a great pity because you have to try and rise above all of that, I think, in a statute like this. It has to be a very high-minded statute. I'm not a musicologist, but it's like the opening bars of Elgar's First Symphony, which are marked nobile mente. Sort of a nobile mente statute is what we require. This reeks of partisanship and pique, which is a great pity. So the whole tone is wrong, and I've no doubt we'll get to the ouster clause in a minute. But and also the dissolution principles do worry me, because I don't think they're right, as I was saying earlier. And I think the essence of the decency bits in that dissolution principle statement should be in the main body of the bill, if you can engineer it that way. So I think it is unsatisfactory, but out of this strange bundle of drafting, something good just might emerge. If you can somehow, as a pre-ledged committee, get the fusion of the best of the ancien regime with the best of a nouveau regime, you'll have taken the trick. That's the great prize for you, and I'm sure you can do it. It's just at the moment, I don't think it's there. It's nowhere near that.
Right, that's very interesting. And Professor Hazell, you said that it was possible to devise a replacement bill that would be less reliant on the conventions and would do the job of replacing the Fixed Term Parliament Act. Do you think that we've got it before us, and how do you think we should try to change this draft bill, or the suggestions we could put to the government as a result of our report? How do you think we should change what we've got in front of us?
Well, coming to your earlier question about the title of the bill, which I think is very undesirable for what will be a fundamental constitutional statute. And it needs to be titled something like the Dissolution and Duration of Parliament Bill. That would give people a much better understanding of what this bill is about. But if I could answer your question in a slightly different way, since Peter referred to retaining the best of the nouveau regime, and forgive me, Chair, I don't know at what point I could say this, but may I briefly mention the respects in which I think those elements of the Fixed Term Parliaments Act which are retained need to be amended. And if I may, I'll very briefly mention 4 respects. The first is, most obviously, we need to remove the 2/3 requirement for a vote for voluntary dissolution and replace it with a simple majority. Because as we saw in 2019, the 2/3 threshold can easily be circumvented by legislation for an early election. So it's pointless to maintain it. Second, there's the silence, which we've already mentioned in Section 2 of the Fixed Term Parliaments Act, about how an alternative government might be formed during the 14-day period if there is an alternative which might command confidence. In practice, I would expect the House of Commons to signal that alternative to the monarch by a resolution or a motion on a humble address, but the silence isn't satisfactory and it's vulnerable to procedural wrangling. So it does need to be filled by some more specific provisions, either by tightening up Section 2 or, and this would be my preference, by drafting some specific standing orders to fill the gap. Third, the provision in Section 2(7) of the Fixed Term Parliaments Act that following a mid-term dissolution, the polling day is set by the Prime Minister. Given the mistrust and controversy this generated in September 2019, it would be preferable for the polling day to be approved by the House of Commons. And we set out how this could be done at paragraphs 28-29 of our written submission. Fourth and finally, there's also a problem that the 14-day period could encompass a time when the House of Commons is not sitting, with the risk that an election could happen against the wishes of members of Parliament. Or indeed, as Anne Toomey warned you last week, that the Prime Minister might seek to prorogue Parliament during the 14 days. We've suggested that those difficulties could be avoided by amending the 14-day period to 10 sitting days. So those are the main respects in which, if you are minded to retain elements of what Peter called the nouveau regime nevertheless needs to be amended.
Angela, could I agree with all of that. Could I add a thought about the title of the bill?
Yes.
It's so boring. It makes it sound like a minor readjustment of the plumbing. And it needs resonance, just like the the Representation of the People Act has resonance. I'd call it the Confidence Act, which is the basis of it, the Mack Act report, which I thought was terrific, the one of September last year, is making confidence the centerpiece of all of this, which of course is what it is. And then, indeed, the House of Lords Constitution Committee, our report was titled A Question of Confidence, though we did put a question mark after it. You need a title that's resonant and will stick to the Velcro of memory. So I'd go for the Confidence Act. It's much, much better. I mean, this one just won't do. There's a complete lack of inspiration in it. Boring as hell.
It can't be a howl of rage and be boring, surely.
No, you're quite right.
Thank you, Chair.
Okay, thank you, Angela. Alan Beef.
Could I just track back for a moment to reasons for refusal? Because it occurs to me that we may have created a new reason why the monarch might be under some pressure to refuse a dissolution. And we're doing so by creating, desirably, I think, a situation where boundary changes cannot be delayed or manipulated by the government of the day or a majority in the House of Commons, but have an automatic coming into effect. And of course, a party leader with a majority in the House might seek to time an election so as to get in before the boundary changes took effect, if they were thought to be disadvantageous. Can you envisage the legislation coping with that, or the existing conventions indeed coping with that?
I hadn't thought of that, Alan. It is a complication. I do remember from the late 60s when Jim Callaghan was Home Secretary and got into a terrible pickle about all of that.
Yes.
He didn't do he got a very good reputation overall as Home Secretary, but that was not the brightest bit of his escutcheon, was it? But I hadn't thought of that, Alan, at all. It really does add a possible complication, doesn't it?
Yes. Does Robert have a view about it?
Well, Lord Beith, I agree with you. I think it is a very desirable change. And it's been made now that the new boundaries cannot be changed because they become automatic on the boundary commissions delivering their final report. But it goes back in a way to my answer to Lord Jay about the unfairness that's inherent in any system where the incumbent Prime Minister can choose the timing of the next election. That's I think, all I would say.
Turning to the Conservative Party's position and government's position moved from the 2015 manifesto, in which they said that the Fixed Term Parliament Act was an unprecedented transfer of executive power. And I think that was in favourable terms, to a position which led to this bill being introduced. And of course, that was brought about by the whole Brexit crisis, which obviously changed their perception. But can we really learn any lessons in terms of the framing of the legislation from the events which had such distinctive features to them, particularly the issue around preventing a no-deal exit by the fixed date? Or are we in danger of writing legislation to deal with something that will never recur in that form, but when we should be writing legislation which, so far as possible, allows the system to cope with whatever new circumstances arise?
Yes, I agree, Alan. I don't think the statute should be shaped by the freakish conditions of the last twitchings of the great Brexit debate. I really do not. I mean, the wider lesson of all of that is that we surely cannot put ourselves through that again. But the parliamentary lessons, I think, are, as I was saying earlier, sui generis. And there's always a danger of legislating on the back of some trauma. And I think trauma is the right word for it, really. It was not the better angels of our parliamentary system in evidence, was it? So I would try and divorce this legislation from that, while understanding the motive power for a lot of it does come from that, quite obviously.
Robert.
I wholly agree. It's clearly convenient for the government to try to pin the blame for the paralysis in the last Parliament on the Fixed Term Parliaments Act. But as a lot of your previous witnesses have pointed out, it's nonsense. My colleague, Professor Meg Russell, has written an article in Parliamentary Affairs analysing the deadlock in the last Parliament and explaining that it was a perfect storm caused by a combination of factors, which you all know, in particular, a minority government with the governing party deeply divided over its flagship policy, and a very weak opposition, which was also divided with no confidence in their leader. Meg Russell identified 4 factors which caused the paralysis, but not one was the Fixed Term Parliament Act. Even without the Fixed Term Parliament Act, we would have had a zombie government, unable to deliver its flagship policy, with a very weak opposition, unable to put the government out of its misery. None of us would want to live through such a parliament again, but it's a travesty to blame its dysfunction on the Fixed Term Parliament Act.
Thank you.
Okay, thank you, Alan. Lord Mancroft. You're muted. Can you unmute?
I think I'm unmuted now. Thank you.
Yeah, that's right.
Sorry for that. The draft bill proposes to revive the prerogative powers that governed dissolution and the calling of new parliaments before 2011. What is your view on the bill's approach to this?
Well, I was cheered up when I read Lady Hale's evidence too, because she found it confusing, the question of whether you could revive the prerogative. And if she can find it confusing, we can all find it confusing. I don't think it's actually crucial, because if you take these solutions that Robert and I are keen on, which is clear-cut votes of the Commons, straightforward majority, I'm always very keen on scholarly debates, because that was my living for a while, and that's how you find exam questions are set each year, is a great debate like that. But in practical terms, I don't think it need detain us very much. I do love scholarly debates, and they quite often shed light on things, but this one, I think, really is angels on head of a pin stuff, isn't it?
Shall I briefly go next?
Yes, please, Robert. Yes, please.
Lord Mancroft, I think it's very undesirable to revive the prerogative powers for all the reasons that have been given by your previous witnesses. In sum, they've criticised the draft bill because it'll lead to uncertainty. It's not possible simply to revert to the status quo ante. In particular, as Peter has said, citing Lady Hale, it's uncertain whether the power revived will be a prerogative or a statutory power. It will lead to uncertainty in not knowing the timing of the next election, making planning more difficult in Whitehall. It'll create unfairness by reviving the power of the incumbent Prime Minister to choose the election date at a time that best suits the governing party. And lastly, it risks drawing the monarch into controversy if there are doubtful requests for dissolution. And the best way of protecting the monarchy is not to revive the prerogative power, but to leave decisions about dissolution where they belong, in Parliament, in the House of Commons.
Absolutely.
Okay, Lord Bancroft?
Yes, no, that's very clear. Thank you very much.
Thank you. Craig Wickeder. Craig?
Thank you, Chair, and thank you both for attending today. Can I just briefly ask about the writs of Parliament? Because as the bill is currently drafted, the writ doesn't have to be issued immediately after dissolution. And as we know, that would take it over the 25-day requirement. Is that acceptable?
Robert, do you want to go first?
Well, clearly it's not acceptable. I would hope this is simply an oversight rather than the government being Machiavellian about this. But the remedy seems simple enough, and that is to tie the issue of the writs to dissolution and to the date of dissolution.
I agree, absolutely.
Okay, thank you, Chair. That's all I wanted to ask.
Okay, John Speller. John, we can't hear you. No, we still can't hear you, John. John, shall we come back to you? We can't. You don't seem to be on mute, but we can't hear anything coming through. Can anybody else hear? Okay, John, I'll come back to you in a moment. Let's move on to Shailesh, please.
Thank you very much, Lord Chairman, and good afternoon to Lord Hennessy and Professor Hazell. The ouster clause, which has already been referred to several times earlier, clearly the ouster clause seeks to determine that it is an area, that this area is something which is an area for political determination rather than for the courts. Professor Hazell has raised one or two issues on it, and I will come to that in a moment. But more generally, what is the problem in a government having a mandate to get rid of a particular act? What is the problem in a government actually setting out in law that the courts cannot intervene? Lord Hennessy, perhaps, to start off with.
Well, there are precedents, of course, for ouster clauses. The 1911 Parliament Act is one of them. But my own view, actually, is that we don't need it. If ever there's a classic territory for Article 9 of the Bill of Rights, 1689, it's this, isn't it? I dug out the wording the other day, freedom of speech, that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. And I think in this instance, Article 9 would rise and ride across the scene in full armour if the courts tried to get involved in it. I can't imagine the Supreme Court would want to touch this, really. If ever there's a classic terrain in parliamentary terms for Article 9 of the Bill of Rights, it's this. But maybe that world, maybe I'm just part of an old assumption there which doesn't hold anymore. But so I can see why people are concerned about it. But the ouster clause, I think, is deeply unsatisfactory, and I would just stand on the Bill of Rights.
That may be so, but what is the problem in making sure, making it even more abundantly clear by putting it in law that this is not something for the courts? Extra measures, or as Sir Stephen Laws put it, a sledgehammer to make it absolutely clear to the courts that this is not something that they should interfere in.
Well, again, the way I've been viewing it is it's yet another delayed reaction to Miller Cherry. That it's a statute drafted in a fit of pique, which I think is very undesirable. So I would stand in 1689.
Putting this bill or the original act in context, Sir Oliver Letwin made it absolutely clear that there was only one reason why the Fixed Term Parliaments Act came into being, and that was to ensure that the Lib Dems had comfort that the Conservatives wouldn't cut and run when it was politically convenient to do so. That was the sole purpose for this act. Given that that objective was achieved, and there was a 5-year government, which the Lib Dems wanted, objective achieved, there is no reason why it cannot be removed. And you therefore have the situation, and I think it was Professor Hazell who said that increasingly you're going to get governments which have small majorities or perhaps even working with other parties. Given that is the scenario that is felt to be the case, we actually have at the moment a political party that had in its manifesto the removal of this act and the restoration of the prerogative powers. This is a government that has a majority of 80, and all it is simply trying to do now is to put in law what it has a mandate to do. So what is the problem in a government trying to fulfill a manifesto commitment? I mean, Lord Hennessy may come in, but I'm mindful that Professor Hazell may also want to come in.
Shall I go first?
Yes, by all
means. 2 points, if I may, in response to this. First, it is a myth that the Fixed Term Parliaments Act was introduced simply to buttress the Conservative Lib Dem coalition in 2010. Fixed Term Parliament legislation had been proposed in several private members' bills in the decades before 2010. Fixed-term Parliament legislation has been introduced around the world, including in the Westminster world, and in the supplementary written submission, which I put into the committee only a couple of weeks ago, I refer in detail to the fixed-term legislation in Canada, in Australia, and indeed much closer to home, in the devolved Parliament in Scotland, in Wales, and in the Assembly in Northern Ireland. And I put in that supplementary submission to make the basic point that fixed-term Parliament legislation is very common in other parliaments, including in the Westminster world, and that it works in the sense that most of the time it does establish a new norm, and parliaments will run to the full term. But secondly, on your point about the government having a mandate, and you referred specifically to the ouster clause, what the government manifesto said was, we will repeal the Fixed Term Parliament Act. Forgive me, there was no mandate for the ouster clause. The ouster clause was not specifically mentioned. But more generally, manifestos, and again, this is a bit of a myth, are not a kind of sacred contract between the governing party and the people. And it is not uncommon for manifesto commitments to be modified or occasionally to be dropped. We've already seen under this government a related commitment to establish in the first year a commission on the Constitution, democracy and rights being quietly dropped. That was announced by the Lord Chancellor only a few weeks ago. So there's nothing sacrosanct about manifesto commitments. The Institute for Government have done quite detailed research on how many manifesto commitments are fulfilled. And again, I can refer you and the committee to the relevant web pages if you want. But I don't think one can make too much of how sacred a manifesto commitment might be, because not all manifesto commitments survive contact with political reality. They're subject to sober second thoughts, testing with experts, and exactly the kind of exercise which this committee, I'm very glad to say, is now going through.
Professor Hazell, if I could just briefly respond, and we could be here a long time, but what may be numerous private members' bills is completely different to what political parties put forward to the nation in a general election. And the point I'm making is that the Fixed Term Parliaments Act was not proposed in any of the manifestos of the major political parties, which I think outrank private members' bills, which are basically those of individual backbenchers. But the other point I would say, in terms of overriding manifesto commitments, where you say that it is often the case that they don't, can I just say that this was not an ordinary manifesto commitment? As somebody who lived through the last parliament and the chaos that we had, to put it bluntly, in the last parliament, members of parliament would come in every morning not knowing whether the business of the day would be as determined by the government, or whether it be the business of the day as determined by the opposition, or whether it would be the business of the day by a small group of MPs in the governing party who were working with opposition parties, or indeed nobody knew whether it was going to be the agenda of the speaker. So given that we had those extraordinary circumstances, and it was the case that a prime minister did seek to call an election, but was prevented from doing so because of this Fixed Term Parliaments Act, we had the extraordinary situation that you had a paralyzed government, which has got to be no good for the nation or for our reputation on the international scene. So given that that was the scenario, and it was an exceptional scenario, and I think everybody talks about the Fixed Term Parliaments Act as it's important, it's necessary, it had a specific purpose. And we saw last time that it was a hindrance to a prime minister being able to go to the country for the country to decide. That is the context that we come from. And given that, I think as Professor Hazell said, that we may end up with minority governments again, you could even have minority governments relying on not having a majority in their own right, even of one. But so to say that to have a simple majority of one should be enough to have a general election, there may well be a scenario where a government cannot command that majority of one, and you have the paralysis that you've just witnessed, or we've all witnessed last year. So coming back to the issue here of the ouster clause, what the government is simply trying to do is to make sure that the courts do not intervene on a very fundamental manifesto commitment that it wishes to push through. Professor Hazell, you, and I'd like you to come back on this, you also say that it would put the monarch in a difficult position. It would put the monarch in no different position that the monarch was in just over a year ago, before Baroness Hale came up with her rules and with her guidelines. So why is it that everything was fine for the monarch just over a year ago, and yet we then have Baroness Hale setting out some rules, and it all becomes extraordinarily difficult to go back to the old scenario? Professor Hazell, please.
Well, if I could just respond briefly on all the points that you've made. First, I wholly agree with you. None of us would want to live through again the last Parliament and its many, many travails. Second, as I said in my responses to Lord Beith, it's a travesty to suggest that any of the dysfunction of the last Parliament was attributable to the Fixed Term Parliament Act. And I refer you to the very careful analysis in the article by Professor Meg Russell, where she analyses what the causes were of the perfect storm in the last Parliament. But none of the factors was the Fixed Term Parliament Act. Third, you referred specifically to the Prime Minister's difficulty in getting a vote to dissolve with the requisite two-thirds threshold. And I've suggested, and I suggest very strongly to the committee, that if you're minded to retain aspects of a fixed-term parliament regime, you should scrap the two-thirds threshold. It's undesirable, and it was also clearly ineffective, because the government was able to easily circumvent it by introducing the Early Parliamentary General Election Act of 2019. Fourth, very briefly, there have been manifesto commitments from major political parties to to introduce fixed-term parliament legislation.
Not at the last election, though. Yeah. I'm specifically referring to the commitments at the last election.
In 2019.
In 2019, yes.
Yes.
Specifically, forgive me for interrupting.
Okay. All right.
I just want to make the point that I'm referring to the manifesto commitments of the last general election, and also, if I may just say that they did say they would repeal it, and they didn't say that they would introduce other legislation in its place. By repealing it, it is implied that it would be the status quo as was before the act was introduced.
Well, we mustn't rehearse all the previous witness sessions that you've had, but I hope it's become pretty clear that the Fixed Term Parliament Act cannot simply be repealed. All the legal experts who've spoken to you have said that that would be extremely dangerous because it would create such uncertainty.
But with respect, Professor Hazell.
Sorry, Cherish, let's give people a chance to answer their questions, and then you can come back right at the end.
Certainly.
Robert.
Professor Hazell.
And finally, you asked me about the risks to the monarch from the ouster clause. And what I said in our written evidence was this: under the government's proposals, in the event of an improper request for dissolution, the Queen would be on her own. Because of the ouster clause, the monarch would lack the advice and protection of the courts. And the government justifies this in the foreword to the draft bill by stating, the long-standing position is that dissolution is not reviewable by the courts, and judgment on the government's actions in such matters should be left to the electorate at the polling booth, or in extremely exceptional circumstances, to the sovereign. But in my view, this offers cold comfort to the palace, because if the Crown is left as the only check on improper or untimely requests for dissolution, it would inevitably be drawn into controversy if such a requests are refused. And this happened in the King-Byng affair in Canada in 1926 and with Gough Whitlam in Australia in 1975. And in each case, the Governor-General's refusal of the Prime Minister's request for dissolution triggered a major constitutional crisis. So the most effective way of avoiding such crises is to leave decisions on dissolution with Parliament, which is the right place for a quintessentially political decision. And as Peter Hennessy has explained very eloquently, if the decision is made by Parliament, then under the Bill of Rights, it's beyond any kind of challenge in the courts.
Can I just add one more? So that historically, Alan Beath will have the figures in his head and I don't, but the Liberal Democratic Party has wanted a fixed-term parliament for a long time. So I think it's a bit unfair to say that the sole motivation of the 2011 Act was to keep the coalition in one piece. I'm sure that was one factor, but it had been argued by many people for a long time that the excessive power of the Prime Minister in this area needed curbing. So there was a high-minded approach to this, as well as an immediate coalition survival motivation. So I think you're being slightly uncharitable towards people in your characterisation of the motives for the 2011 legislation.
Lord Hennessy, I'm merely quoting or paraphrasing one of the key people involved in those negotiations, and that is Sir Oliver Letwin, who was the representative of the Conservatives in those negotiations. And he himself said, and you can look back at the evidence when he gave, that was the purpose. I'm simply, forgive me if I'm being uncharitable by simply quoting one of the key players in those negotiations.
I respect Oliver greatly, but I think he was wrong about that.
Okay. All right.
Okay. Can I conclude by just saying one thing, Mr. Chairman, and we could be here
very briefly, Shirish.
I just want to say to Professor Hazell that when he says that there are a number of people who said that it would be not right to repeal the Act, I think if we look at the wording carefully of the people, very few of them are definitive in saying that you can't repeal the Act and it would cause chaos. Many of them have concerns, but having concerns is different to being definitive not to repeal it. And can I just conclude on saying that, of course, Lord Sumption, one of the country's most respected former Supreme Court judges, has said that the ouster clause should be respected. It is what the government wants. And Sir Stephen Laws, of course, one of the country's leading counsels, likewise is definitive. So you have two of the country's leading lawyers being absolutely clear in their language that the ouster clause is valid. And you have a whole lot of other people who are not definitive, but just raising various caveats. Thank you, Lord Chairman.
Thank you, Shirish. Right, John, are you now back with us?
Well, can you hear me?
Yes, I can now, fine.
That's even better. I think one of the problems, so many colleagues are at home, they feel the need to talk endlessly when they get the opportunity. And can I also say, in response to Lord Hennessy's comment about this being done in a fit of pique, that, of course, this committee has actually been set up in a roundabout way, and that the legislation said a committee should have been set up in order to take evidence and report, and that should have formed the basis of the legislation, rather than the legislation being considered by the committee. Can I then come on to Professor Hazell? Because I thought he said that Australia had fixed-term parliament acts. Now, it's certainly true for the states, but is that true at the federal level?
No, it's not. And forgive me, in all the Australian states, bar one, Tasmania, they have introduced fixed-term legislation over the last 15 years or so. And you heard eloquently last week from Anne Toomey from New South Wales, which was the first state to introduce fixed-term legislation from memory in 1995. But at the federal level, you're absolutely right. They don't have fixed-term legislation, but they do, unusually, have a maximum term of 3 years.
That's a different issue, because isn't that in any way dissimilar from here, where councils and and Scotland and Wales have fixed terms, but the equivalent, therefore, the federal parliament, the national parliament, is frankly in a similar position to Australia, isn't it?
Well, at the moment, until the Fixed Term Parliaments Act is repealed, we do have fixed terms. And if I could briefly touch on Canada, and I'd refer you to the supplementary submission, which I put into the committee about both Australia and Canada. At Canada, they do have fixed term legislation at the federal level, as well as in the Canadian provinces.
I also then come on, just briefly touch on the, because you've mentioned here and also in the submission about the Whitlam government. But wasn't the underlying problem that the Governor General, acting on behalf of the monarchy, was in fact taking advice from the leader of the opposition rather than from the Prime Minister? Indeed, was conspiring with the leader of the opposition.
Well, we should recall Professor Toomey, who's one of the world's leading experts about the constitutional crisis in Australia in 1975. And forgive me, I'm not. All I can recall in brief is that the Whitlam government could not get supply, which was blocked in the upper house, the Senate, which in Australia has power over finance matters. And Whitlam requested a dissolution.
Only a half dissolution of the Senate, not of the House of Representatives, which should actually have been in charge of supply.
Well, the Australian system is not the same as ours, and the Senate did have power and could veto supply, and that was Gough Whitlam's difficulty because he didn't have a majority in the Senate. But I don't think the chairman will thank us for discussing at great length the Australian crisis of 1975.
In that case, can I return to the question that has been allocated to me on this? And Peter Hennessy described the dissolution principles as not adequate. But does he? Do you think that the document actually adequately captures the conventions on dissolution, on the calling of Parliament, and government formation as they existed before the Act?
No, I think, John, the problem is it's not precise enough on the two concepts of advice, the capital A advice and the lowercase advice. The monarch doesn't have to accept, and also the verb request. The Lascelles principles have the verb request. The Prime Minister can only request a dissolution, and the Cabinet Manual repeats the Lascelles language. And I think in the dissolution principles here, it's got to be much more in line with the Cabinet Manual and the Lascelles principles. It's just, again, I suspect it was done in a rush, really. And also, it doesn't exactly, it's sort of back of an envelope of the worst kind, isn't it? It doesn't read as a kind of the sort of language you would expect it to, given the magnitude of the questions it's addressing. I think it's an unsatisfactory piece of drafting as well.
So can I be clear? Do you think that talking about advising rather than requesting actually represents a change in substance?
Well, I think it's the assumption that request rather than demand or advise, and that the advice question is very precise. Again, I think I might have quoted Martin Charteris directly earlier in this session, that he said that you always have to distinguish between capital A advice, which the monarch always accepts from ministers, and lowercase advice, personal prerogatives, where they don't or don't have to. And I think that needs to be made plain so that the continuity, the historical continuity, which I think is terribly important in constitution crafting, is maintained. That's all I'm saying, John, I think, really.
Thank you very much.
Okay, John, thank you very much indeed. Could I ask Peter Hennessy, on all your experiences, when you talk about the public knowing when an election's going to be, I mean, of all the elections I can recall, people have generally known when the election is going to be, or there's an election in the offing, apart from probably the 2017 election.
Yes.
Could you give me any other examples where an election was called sort of without the public being aware that there's about to be a general election, or indeed a lot of views that there was going to be a general election?
The only one I think I can remember being a bit of a shock, and it was only a bit of a shock, was Harold Wilson going in June 1970. And we were a bit surprised that he was going that soon. And it was, of course, it rebounded on him. the electorate, if there is an iron law of electoral history, I suppose it's that the electorate gets very fed up if there's a general election where there doesn't need to be one. I mean, Willie Whitelaw after 74 is a very shrewd man, observer of these things, saying, if you have a whole rules general election, people turn back and say, we thought you were governing. And it's the it's the knicker elastic theory of elections, that it snaps back on you if you foist an election on people when you don't need to.
Which is much what Robin Butler said to us as well. Lord Beef, you just wanted to make a point there?
I was just quoting Ted Heath in February 1974. He had a reason to call an election, but it was an unexpected election. And a lot of MPs found themselves retiring a little earlier than they'd expected to do. Okay. And there was less surprise about the October election in 74. The only question there was when it would be. But if he'd asked for it in March, April 74, I think the Golden Triangle might have asked him if he would leave his call to the palace to a little later in the year.
Okay, I've got a couple of people who want to make comments. I have seen them. Maria Miller, Chris Bryant, and Bruce Grocott. Chris, do you want to come first, and then Maria?
It's very quick. I remember at least one general election which didn't come about when we thought it was going to happen, which is when Gordon Brown became Prime Minister. And that destabilised government, actually, considerably.
The last time we expected an election in October 78, didn't we? And Jim delayed.
Yes. Yeah, Callaghan.
There was I waiting at the church, he said.
Sang the song to the Congress, didn't he?
Okay, Maria?
Chair, much as I'd like to examine further the knicker elastic rule of politics, I just wanted to clarify one very simple point, and I realise I maybe I didn't catch this in the discussion. Could I just confirm neither of our witnesses think or advocate for the retention of the Fixed Term Parliament Act as it is? And I just perhaps gently remind them both that it wasn't just the Conservative Party who had in their manifesto to repeal the Fixed Term Parliament Act. The Labour Party had it in their manifesto as well. Can I just get very simple clarification on that point, first from Professor Hazell and then from Lord Hennessy?
Yes, so I'm certainly not advocating retaining the Fixed Term Parliament Act as it is. It's clear that if it is repealed, there will need to be a replacement statute, and the whole discussion I hope of this committee is going to be what should be in that replacement statute. And during my evidence, I listed 4 respects in which, if we do continue to have a fixed term parliament regime, and I hope that we shall, the existing fixed term parliament legislation needs to be amended. I won't repeat those 4 respects now, but they'll be on the record.
Thank you, Robert. You did mention. Peter?
I think it should go. It's almost friendless, not entirely friendless, but it should go. I think to use the terminology that matters, people have got no confidence in it anymore. And that's a very unsatisfactory position. But again, to adapt Arthur Balfour on dissolutions, we can't go on going around this circuit forever. This is the time to get a settlement that will hold, and I'm sure you can. I'm sure you can find a way through for all of us.
Thank you.
Bruce?
But yes, just on the question of unexpected elections, you've gone to a period there, and this I'd like to ask a question of Robert Hazell on this one. That there were 4 elections there, weren't there? The 1970 election, which was unexpected and didn't get the result the Prime Minister wanted. The February 1974 election, where ditto. The October 74 election, where the Prime Minister expected to get a substantial majority and didn't, and of course the 79 election, where James Callaghan certainly didn't want Margaret Thatcher to be Prime Minister. Now, the only reason I mention all of those unexpected elections with results which the Prime Minister would not have wanted is to relate to Robert Hazell's point about the research saying what an advantage it was to a sitting government, but more specifically to him, to ask him this question. He's several times said that was unfair, which I'm not saying I necessarily disagree with, but that it should be replaced by the Commons making a decision. Now, the Commons, almost by definition, will have a majority that will agree with the Prime Minister when required to on the matter of elections. So it seems to me that the Prime Minister of the day requesting an election and a simple majority in the House of Commons deciding on a general election date. And we're all agreed that the 2/3 decision requirement was ridiculous. They amount to pretty much the same thing.
Well, if I could respond briefly, in effect, by reminding me of those elections where there's been a slight surprise to the Prime Minister, you're really challenging the evidence of Professor Petra Schleiter. And as I said in my reply to Lord Jay, if there are members of the committee who want to question that evidence, then I really would encourage you to invite Petra Schleiter to give evidence to the committee. Because for me, research is very careful. As I said, it's highly respected, and her conclusions are incontrovertible. Secondly, you asked about giving the decision on dissolution to the House of Commons. Let me make it this clear that under fixed term legislation, parliaments will normally run for their full term. And that was the whole purpose of this supplementary submission, which I put into the committee to demonstrate that that is what happens in practice in those Westminster jurisdictions that have fixed term legislation. But just to take one example, the example closest to home that you will know about very well, in Scotland, in Wales, in Northern Ireland, they have fixed term legislation, and we take it for granted that their parliaments will run for a full term, and they do, and they have, with only one exception. And my evidence also goes into the experience in Canada and Australia, where the norm, if you have fixed term legislation, is for the parliament to run for the full term. And the only circumstance in which the House of Commons then decides on dissolution is if there's a deadlock or a vote of no confidence, and that then triggers a vote on whether there should be an early dissolution. So that's the only circumstance under fixed term legislation when Parliament gets to decide.
But that's a simple majority, which the Prime Minister can be fairly confident of getting.
Well, it depends entirely on the political circumstance and whether the Prime Minister has got a majority, as you're supposing. But you're right. And please, I would encourage you to read my supplementary submission, because I make the case that fixed term legislation is not a set of fixed rules. And therefore, some people have suggested it's a misnomer to call it a fixed term Parliament Act. It creates a new norm. And what I tried to explain in the supplementary submission is that most of the time, in most parliaments, for most of their parliamentary terms, that norm is observed. It works. Chair, if we're coming to the end, I would like just to say something very briefly by way of a final remark, if I may.
Are you okay with that, Bruce? You finished now.
Well, I just don't agree, but we'll go on forever, I suppose.
Okay, fine. Okay, Robert, if you want to just your final remarks, please do.
This will be very brief, and it's making one simple but really fundamental point. At bottom, this whole discussion has been about where power lies and where it should lie in our parliamentary democracy. So should the executive be accountable to Parliament, or should Parliament be accountable to and controlled by the executive? And the government's draft bill, to my mind, and that of several of the other witnesses who've given evidence to your committee, is a bit of an executive power grab. It's an attempt to ensure that Parliament is controlled by the executive, that the executive should decide when Parliament sits or is dissolved. But I hope that as a group of wise and experienced parliamentarians, you will stand up for parliamentary sovereignty, for the principle that decisions about dissolution and prorogation properly belong with Parliament, because Parliament's the central institution in our democracy, and Parliament should decide when it's dissolved or prorogued. So that is my parting thought.
Thank you. Thank you very much. Peter, I don't know if there's any point you wish to finally summarise with.
Just one remark at the end. We began with confidence, and I'd like to end with it. I've got great confidence in your committee chairman to do this, to pull it off, to blend the nouveau and the ancien. And you'll have the hosannas of a grateful nation when you do so, not least from me.
Well, thank you very much for that. I'm going to share a comment which I haven't got permission to do, but Chris Bryant did text me to say good luck with getting consensus on this. I think that is certainly the case. Can I thank both of our witnesses, both Lord Hennessy and Robert Hazell, for their forbearance and their answering of the questions in very thoughtful ways this morning. I think it has been a fascinating session which has answered some of our questions and led us to think a bit more about some of the other issues which are there for us to address. So thank you very much for participating this morning. Order. Thanks.
Meeting has ended.